good to be with all of you. I appreciate your attendance, and I look forward to these kind of events where we're able to talk about the areas of practice that I concentrate on. Like Lauren said, I'm a lawyer that's licensed to practice in the state of South Carolina, and my law firm, we focus on the topic that I'm going to talk about today, estate planning and elder law. There are multiple areas of the law. I'm not very helpful if you get a DUI or you have any problem with the police, but what we do is a lot of transactional law related to estate planning, which includes dealing with wills, dealing with the probate court, trust planning, powers of attorney, incapacity. So I'm going to kind of give you an outline or an overview of some of those issues, some of the things that you need to know as South Carolina residents and that are important for everybody that's over the age of 18. And whether you are single, married, young or old, these issues will impact you and your family. So not a lot of resources available. And so I appreciate, times like this where we can share information. So like Lawrence said, my law firm is Burroughs Elijah Attorneys. We have an office located in downtown Greenville on East Coffee Street. And so if you have any questions after the presentation, feel free to contact us. I'm sure that my contact information will be provided to you by GAPS. So I kind of want to just start out the presentation giving you just an overview. When we talk about estate planning in general, a lot of people want to know, well, what does that actually mean? I don't have an estate. But most people do. You may have real estate, you may have investments, you could have your personal property, contents of your home, you may have a vehicle, you have life insurance and retirement accounts. Those things are all part of your estate. And so when you have assets that you've accumulated during your lifetime, there's a couple of important issues that you need to pay attention to in dealing with them. The first important issue is incapacity. What happens during your lifetime if you have a health event, which I know many of you have dealt with in your family? But what if there's a health event and you're unable to handle your affairs? What happens at end of life? What happens when you pass away? Those are the two primary goals or objectives or issues that we deal with on a regular basis. As sort of a baseline, when I'm dealing with these two issues, incapacity and end of life, there are a few essential documents that everybody needs in the state of South Carolina. One is a durable power of attorney. This is otherwise known as a financial power of attorney or a general power of attorney. Those are all the same thing. This power of attorney is responsible or is used rather to deal with your financial and property obligations should you have some health event during lifetime. A healthcare power of attorney is also important, or a healthcare directive. This document allows you to nominate one or more agents that can handle your healthcare decisions if you are unable to talk to your doctor, communicate with your physician, your attending physician, or the hospital, and you can't make your own healthcare decisions. The healthcare power of attorney is what allows someone else to communicate on your behalf and make those decisions for you. So those two documents, those two power of attorney documents, are essential to deal with incapacity in South Carolina. Just because you're married or you have children or you have close family members, it doesn't mean that those individuals have any authority to handle your affairs if you have a health event during lifetime. The only way that we can empower our spouse or our children or other family members to handle those issues for us is by signing a power of attorney document. So the durable power of attorney and the healthcare power of attorney are two of the critical documents that every adult in the state of South Carolina needs. The second issue that I mentioned was end of life. So how do we deal with end of life? The powers of attorney become void when we pass away. And so they have no power anymore. There's no authority that's vested in the agent that we've nominated in our power of attorney upon death. Most often, people have a last will and testament. And so the last will and testament is only effective upon our death. And it does the same thing generally that a power of attorney does. It gives someone authority over our estate, over our assets, over our obligations when we're deceased. And so we'll talk a little bit more about how we use the last will and testament. but those are the three essential documents that everybody in the state of South Carolina needs. So if you're missing one of those documents, I would tell you to definitely go in, dive deep and do a little bit more research. Make sure that you have at least those three documents as part of your estate plan. The way that I've kind of divided up this presentation is I want to talk about the basic estate planning tools that we use depending on a individual or family's personal situation. We mentioned the need for a will, right? And so that's one of the main estate planning tools that we use. But there's also some other tools that we can use depending on circumstances, like if we have beneficiaries that are disabled, if we want to avoid the probate court, or we're concerned about long-term care, there's other tools in addition to the will that we need to consider as part of our estate plan. So the other three tools that I'm going to talk about today include the Revocable Trust, which is an alternative to a will plan. We'll go over that. The Special Needs Trust, which is typically only employed when we have disabled beneficiaries that we want to protect upon our passing. And then the Irrevocable Trust, which we use now for long-term care planning purposes, when we're concerned about potential nursing home, especially, or if we are concerned about assisted living, memory care, and how to pay for that in the future. There are some tools that we can use, like an Irrevocable Trust, to protect some of our assets. And so these are the four sort of category of tools that we're going to talk about. But let's start out with the last will and testament and go a little bit more specific. Like I said, in South Carolina, everybody needs a last will and testament. It is sort of the centerpiece of most traditional estate plans. And I've got some answers here on what a will does, or what is a will. It identifies who your beneficiaries are. It identifies what your beneficiaries are going to receive from your estate after you're deceased. And it identifies who's in charge after you're gone, the person that's responsible to carry out your wishes. That's known as a personal representative. You nominate your personal representative in your will. Like I mentioned earlier, the powers of attorney are used during lifetime. The will is only used after we're deceased. And so the will doesn't have any power during our life, but when we're gone, the will becomes effective. So what do we actually need a will for? Why would we have a will? In estate planning, there are two basic categories or major categories of property or assets. We have probate assets and we have non-probate assets. Non-probate assets include traditionally life insurance, retirement accounts, those accounts or assets that have beneficiary designations. When someone passes away, owning a life insurance policy or retirement account with a beneficiary designation, that account or the death benefit from a life insurance policy will be paid directly to the named beneficiary without any need for a will. Okay, so we avoid the use of a will in dealing with those assets. Another type of non-probate asset would be an account that is joint with right of survivorship. So many times if you're married and you open up an account at the bank, a checking or savings account, that'll be a joint account that both spouses share, and then it is available to the surviving spouse automatically because it's joint with right of survivorship. Another example is any assets that are in a trust are considered non-probate assets. We'll talk more about that in a few minutes. The traditional probate assets, however, include your real estate, typically your residence or any other property that you own. If you have stocks, bonds, mutual funds that are in your individual name, if you have any single owner bank accounts, and then the contents of your home, the personal property. These are all considered probate assets. All the probate assets go to the beneficiaries that are nominated or named in your will. And so we end up having to actually go through the probate court, the probate process in dealing with those probate assets. So we kind of have these two parallel types of assets, right? And they're treated differently based on the type of asset it is, whether it's non-probate or it's probate. So in the state of South Carolina, every last will and testament must go through the probate court in the county in which the decedent or the deceased person resided at their time of death. And so the last will and testament doesn't automatically have power when you're deceased. We have to go through the court system. The probate court will review the will and then nominate or appoint the personal representative and give them authority over your estate. So what does that process kind of look like? I've got an outline here of generally what's required. We typically file the original last will and testament with the court. We have to notify the family in a particular way. Typically, when the personal representative is appointed by the court, they will receive a court-issued document. It's called a certificate of appointment. The certificate of appointment is what the personal representative would use to do business on behalf of the estate. And so typically, if you go to a bank or a financial institution, or you try to sell a house that's part of the estate, you need that certificate of appointment. So once the certificate of appointment is issued, we have to notify the family, the heirs at law. If you are married and you have children, your heirs at law include your spouse and your children. If you are married and have no children, your heir at law is your spouse. If you're unmarried and you have children, your children are your heirs at law. If you have a deceased child, your grandchildren would be, the children of your deceased child would be considered heirs at law. So it really depends on who's living as to who we have to inform about the probate process. Typically in South Carolina, we don't have to get the consent of the heirs at law. We just have to notify them of the process in general. So when the personal representative is appointed by the court, we notify the family. A couple of the responsibilities of the personal representative, that includes an inventory of the probate assets. They are responsible to gather information about any real estate, any accounts that are owned by the estate. And so again, we're looking at probate assets, only the assets that are owned by the individual decedent. We don't really include life insurance, retirement accounts, things like that. Those are going to be processed separately for the beneficiaries. Another obligation that the personal representative has is to deal with any debt obligations or financial obligations that the decedent had. We have to file taxes on behalf of the estate, and the personal representative is the only one that can do that. But once we have a good inventory of all the assets, and then once the debt obligations have been taken care of, ultimately we can make distributions to the named beneficiaries in the will. In South Carolina, this whole process generally lasts about a year. Unfortunately, one of the requirements under South Carolina law is that when you file the will and a personal representative is appointed, we actually have to wait 8 months for creditors to make claims on the estate. The law gives creditors up to 8 months to make claims. That doesn't mean that we have to just sit and wait on the creditors, but it does mean that it will be a while before we can actually make distributions ultimately to the beneficiaries and close out the estate. So on average, we spend about a year in probate court taking care of these 6 steps. A couple of challenges that we face in probate. One that I already mentioned is delays. It takes us about a year to get through the process. Sometimes it can stir up family drama. Sometimes the last will and testament ends up being different than everybody anticipated. Sometimes in cases where someone doesn't have a will, we still have to go through the probate court, and we still have to involve the heirs at law, spouse, children, grandchildren potentially, and the division of assets can get kind of complicated if you don't have a will. And so sometimes the family drama is an issue. Again, probate only controls certain assets. And so many times what you have to make sure is that the beneficiaries that you have on your non-probate assets match up with the beneficiaries that you have in your will, that you have a consistent estate plan, okay? A couple other challenges, if you have real estate in multiple states, say you own property in South Carolina and North Carolina, most often we have to go through probate in both states, not just South Carolina where you reside, but also North Carolina where you own property. If you own a business, sometimes that is an issue. You know, when a business owner passes away, the business has to continue, and there may be obligations that we need to take care of, like payroll, taking care of employees, taking care of customers. And so for a business to get wrapped up in probate can become a problem. And then if we have particular beneficiaries like minor beneficiaries, young children, grandchildren, or if we have a disabled beneficiary. Probate doesn't always protect those beneficiaries the way that we would want to. And so we've got to make sure that we've got a plan for those types of beneficiaries. So one example of something that we can make sure is part of our will plan, and you see this quite often, is the creation of a testamentary trust for children or other beneficiaries. So this is an example where we've got Sarah who passes away. She owns a home and she's got life insurance, okay? We have to look at the probate property and non-probate property in this scenario. The life insurance has beneficiary designations, right? And so that's considered non-probate property, and it will be distributed to the named beneficiaries where Sarah named her children. But on the probate property side, we have the house, and her will controls how the house is distributed upon her passing. And what she said in her will is that she wants the house to be held for her minor children's benefit up until they reach a certain age. And so in this case, we kind of have the possibility of two different estate plans where the life insurance might pass to the young children when they turn 18 because they're adults, but the house is held for them until they reach 25 or 30 or whatever Sarah's plan was. And so one of the things we have to reconcile is making sure that we address both probate assets and non-probate assets and make sure that there is a consistent estate plan between the two. Let's talk about the second tool, the second estate planning tool that I wanted to mention today. This is the Revocable Trust, or some people call it a living trust. That's the same type of trust document. The way that I look at a trust is it's sort of like a box. It's a box that you can create during your lifetime. There's three main parts to it. There's the trustee, who is the responsible party, the person who manages the trust. There's trust property. These are assets that we can actually put inside the box. That might be real estate, that could be cash accounts, investment accounts. Those become part of the trust property. And then there's the beneficiaries. There's both lifetime beneficiaries and death time beneficiaries for a trust. So when someone creates a revocable trust, like if I were to create a revocable trust for myself and my family, I'm going to name myself as the trustee. I may put some of my assets into the box, into the trust that I control during my lifetime. I'm going to also name myself as a lifetime beneficiary so that I can access anything that I put in the trust. But upon my passing, I'm going to have death time beneficiaries, which might include my spouse, might include my children, and they're going to be taken care of using those trust assets after I'm deceased. So it has the same type of the same type of provisions that you would find in a last will and testament, right? We have beneficiaries after we're deceased, and we can also name what's known as a successor trustee, somebody that takes over control of the trust after we're deceased. They're responsible for managing the trust assets for our death time beneficiaries. So the revocable trust is actually an alternative to the last will and testament. In states like South Carolina, the revocable trust has become a popular alternative because it avoids the probate court. And that's the main difference here, is whereas with the last will and testament, we have to go through the probate court when someone passes away. With a revocable trust, if properly, and tie someone's assets to the trust, we don't actually have to go through the probate court in order to take care of their beneficiaries and administer their estate after they're deceased. So probate avoidance is the primary objective. There's a couple other considerations for the revocable trust. Is privacy is one. You know, whereas when we file a will with the probate court in the county where someone lives, that becomes part of the public record, and it is available essentially to the public. With a trust, there's only a few individuals who are allowed to view the trust document. That would include the creator, you. That would include your beneficiaries that you name, maybe your family. And it would include the trustee that you name to follow up and be in control after you're gone. Sometimes there is a cost difference as well. So with a last will and testament, typically you're going to pay a little bit less on the front end with a lawyer to create a will plan. But when you pass away, you typically will hire an attorney to the family will hire an attorney to take them through the probate process. And so many times it ends up actually being more expensive for a will plan and going through probate than it is to set up a trust in the beginning. And then we also have to consider family dynamics. There are different types of beneficiaries that we have to consider. What if we have children or beneficiaries that have addiction problems, troubled marriages? If we have young beneficiaries, if they have problems managing money, if we have a disabled beneficiary, or say we have blended families, these are all dynamics that a last will and testament sometimes is a difficult vehicle to use to take care of these types of beneficiaries. We want something that will deal with some of these dynamics. And a trust is a great vehicle to take care of young beneficiaries, disabled beneficiaries, or any other problematic beneficiary that we can imagine. So the primary difference, we've got an outline here between the last will and testament and the revocable trust plan. Most people in the state of South Carolina will choose one of these plans. You'll either have a will plan or you will have a revocable trust plan. During life, the will is not effective. It doesn't have any power. There are no lifetime provisions. But after you're gone, the probate assets that you leave behind, the assets in your individual name, are disposed of by your will. But the probate court is involved. The will doesn't have power automatically. We have to go through the court system. The revocable trust, it is established during life. Like I said, it's sort of this box that we can put assets inside of. There are lifetime provisions. The revocable trust says that sorry about that. The revocable trust says that I am the beneficiary during my lifetime. I'm also the trustee. So I control the trust during my lifetime. After I'm gone, the trust will dispose of all the trust property to my named beneficiaries, but we do so avoiding the court system. We don't have to deal with judicial intervention in administration of the trust. All right, let's move on to the third tool that I want to talk about. This is the special needs trust. All right, so far we've talked about the last will and testament as the primary estate planning tool that we use. As an alternative, we have a revocable trust plan that we can use sometimes to avoid the court to deal with specific types of beneficiaries. The special needs trust is another tool that we have to consider, especially when we have a disabled beneficiary that we want to protect. The purpose of the special needs trust is to protect inheritance that may be left to a disabled person so that we preserve their means-tested benefits like SSI and Medicaid. One of the things that we don't want to happen is if we leave assets to a disabled person, we don't want to inadvertently kick them off of the benefits that they're currently getting. And so we have to consider that as a distinct possibility when we're creating an estate plan. The special needs trust, there's really two types of ways we can create this. One way is in our will, we can say, all right, I want to leave assets to my grandchild, my disabled grandchild, but instead of an outright distribution to them, we're going to create a special needs trust for her where the inheritance will be held for her benefit, but it won't impact her eligibility for Medicaid. Another way we can create a special needs trust is during lifetime. We can actually establish a separate trust during our life, and we can fund it during our life, or we can invite others to fund it during our life. And that special needs trust will be held for the benefit of the disabled beneficiary. And it's a trust that we can actually manage on their behalf. So there's two ways to do it. We can either create the special needs trust upon death in our will, or we can create the special needs trust during our lifetime and fund it. What's really powerful in the state of South Carolina about the special needs trust is that parents or grandparents or other family members can contribute to this trust, and any assets that are distributed to it either during their life or after their death are protected and do not count against the beneficiary automatically. There is no wait period. There is no question about those assets not counting against the beneficiary. So the special needs trust is a very powerful tool that we always need to keep in mind. All right, let's talk about the fourth tool, which is the irrevocable trust. The irrevocable trust comes into play when we are dealing with long-term care, okay, when we're concerned about long-term care planning. And the reason that most of us are concerned about long-term care planning is because of the statistics. The U.S. Department of Health says that about 70% of people who reach the age of 65 will require some level of care during their lifetime. Now, that doesn't mean that that 70% of the population goes to the nursing home, but it does mean that 70% of the population either requires nursing home care, they might require memory care, assisted living, or in-home care. And so when we have a family member or we're planning for ourselves in dealing with long-term care, we have to consider those statistics. Over the course of time, and I know a lot of you have probably experienced this, the cost of long-term care has gone up and up every year. And so we have to consider that in the next 5-10 years, that the cost will continue to climb for in-home care, assisted living, memory care, and skilled care. So what my law firm has found in dealing with these levels of care is that there are some average costs at this point. For in-home care, for a certified nursing assistant or an RN to come into the house, typically going to pay anywhere from about $16 an hour to $26 an hour for that individual to come in. For assisted living, at a minimum, we're really looking at about $3,500 for a single person, up to $4,500, $5,500. For memory care, minimum, you're looking at about $4,500 a month, up to $6,500 a month. And then for skilled care, on average, you'll pay anywhere between $8,000 and $10,000 per month. So the cost of care is tremendous. There are a few benefits that will help with the cost of care for individuals that don't have a lot of assets or a lot of resources or don't have long-term care insurance to help them out. VA aid and attendance is one benefit that is available to veterans and their surviving spouses. Medicaid is another benefit that's available. There's a couple of criteria that I'm going to go over for each benefit, just generally speaking. For VA aid and attendance, there's 4 things that the VA looks at. One is the veteran service. The applicant has to be an active duty military member for at least 90 days and at least 1 day during a specific wartime period. The VA has specific dates that are laid out on what constitutes a wartime period. And so you have to have served at least 3 months active duty, 1 day during one of those wartime period, and then had no dishonorable discharge. So that's sort of the threshold question. I just had a call yesterday actually from an individual who was a merchant Marine member. And unfortunately, some areas of the armed forces, like merchant Marines, aren't considered active duty most often. And so we have to pay very particular attention to the discharge paperwork or the DD-214 that the veteran receives to determine whether or not that they qualify under the wartime service requirement. The second item that the VA looks at is the health of the applicant. Typically, what is required is the VA wants to see that you are 65 years of age or older and that you need assistance with at least 2 activities of daily living, okay? And so what that means is we have to get a doctor's examination done. There's a VA form 212680 that the physician, your attending physician, will fill out. And they have to determine that you need assistance with 2 activities of daily living or more in order to qualify at the highest rating for the health criteria. The third element that the VA looks at is the income of an applicant. And so if an applicant is married, the VA looks at both spouses' income in making this determination. But the bottom line essentially for the income test is that you have to be spending most or all of your regular monthly income on care or other unreimbursed medical expenses. So if you have a mortgage or you have other expenses that your income is paying for, the VA doesn't count that. But if you are spending your income, most or all of your income on care, you will pass or meet the income standard that the VA has laid out. The last element that the VA looks at is your assets. They want to know about your net worth. If you have $127,000, and this has actually been adjusted a little bit, it's a little higher than this, closer to $130,000 or less in resources, you meet the standard for the VA asset test. If you're married, both spouses' assets are included. There's a few assets, though, that are non-countable. Your residence is a non-countable asset. If you have a vehicle, it's non-countable. Your personal property or the contents of your home are non-countable assets. If you have anything related to burial plots, or an irrevocable burial policy, that's non-countable. But everything else, IRA, investment accounts, cash accounts, if you have a second piece of property, that's all countable. And the resources have to be less than $130,000 in order to pass the asset test. One other point that I make here is that the VA has instituted a 3-year look-back period. It used to be the case that you could give assets away and there was no penalty. They changed that rule in 2018. Now, if you were to give away assets to try to get your net worth below 130, the VA will penalize you for that gift. And what that really means is that there's going to be a delay in the time that the VA benefit would be available to you. So gifting is an issue for the VA benefit now. So just as a summary, the VA looks at 4 elements. They look at the military service, they look at the health of the applicant, they look at the income of the applicant, and the net worth. Let's take a look at Medicaid. This is the other resource or the other benefit that's available to help pay for long-term care expenses. The VA benefit is helpful in paying for long-term care like in-home care, assisted living, and nursing home. And the way that the VA benefit pays out, it's a monthly stipend. Medicaid is a little bit different. Typically, in the state of South Carolina, Medicaid will only pay for skilled care nursing. There are some other Medicaid waiver programs for assisted living and in-home care, but the number of facilities that are Medicaid facilities that are assisted living or memory care, they are dwindling. There's not many. And so the nursing homes are really the only reliable way to qualify for Medicaid. Of course, Medicaid is different than Medicare. Medicare and Medicaid are sister programs. They overlap a little bit in dealing with skilled care, but they are completely separate. So typically, when someone enters a hospital because of an injury or illness, they're treated at the hospital, and then they're discharged to a nursing home for rehab. Medicare will cover 100% from days 1 to 20. 100% of the care will be paid for by Medicare. From days 21 to a maximum of 100, Medicare will pay part of the bill at the nursing home. Okay, they require a payment from the applicant, though, to pay for part of that care from days 21 to 100. After a maximum 100 days, Medicare payments stop to the nursing home. So if you have to remain at the rehab facility or in the nursing home, you are now considered a private pay resident. And what that means is you have to pay out of pocket the $8,000 to $10,000 a month that it costs to stay at the nursing home. That's where potentially Medicaid can come in. If you qualify for Medicaid, Medicaid will pay the nursing home the cost of care above your income. So typically the applicant is the resident who is in the nursing home. What Medicaid requires is that your income is typically paid to the nursing home. Medicaid will pay the difference in the cost of care and your income. So who qualifies? For the Medicaid benefit, there are 2 tests that the state looks at. One is the income test, and the other is the net worth test. For income, the state of South Carolina says that if you have more than about $2,300 a month in income, you are not qualified for the Medicaid program. However, there is something called a qualified income trust account. This is an administrative account that can be set up, and the Medicaid requires that your income be deposited into this trust account every month. And if you have more than $2,300, the QIT, or the Qualified Income Trust account, is required. So the bottom line here is, even though the income cap for South Carolina is about $2,300, if you have more income, you still can qualify. You just have to have the Qualified Income Trust account set up. And so the public policy behind that, or the purpose, is that Medicaid wants to track your income. They want to make sure that any income over $2,300 per month is paid to the nursing home properly. And so they require you to have this additional administrative step to qualify for income. Now, another question that comes up for Medicaid income is when you are married. So what if one spouse is in the nursing home and then one spouse is at home? What Medicaid says is that the spouse who's in the nursing home, their income is who's paid to the nursing home. The spouse that's at home, we call that the community spouse, their income can be kept by them. They don't have to contribute to the nursing home. However, if the spouse at home makes less than $3,000 per month, the spouse at home can draw over enough income from the nursing home spouse to make sure that they're left with $3,000 a month in family income. So the whole public policy behind that is that Medicaid wants to make sure that a healthy spouse at home has at least $3,000 in income, no matter if their spouse is in the nursing home. The second test that Medicaid has is the net worth cap. In South Carolina, a married couple can have up to $68,000 in resources. Okay, so we kind of looked at the net worth cap for VA a few minutes ago. That's at 130. In South Carolina for Medicaid, it's all the way down to 68,000. For a single individual, you have to spend your net worth all the way down to $2,000 in order to qualify for nursing home Medicaid. Most people are on what we call the spend down plan. You may have assets that are above the $2,000 mark or the $68,000 mark, and you simply have to spend those assets down on care until you get to that level. And so without any planning, this is what most people go through. I will mention there are some exempt assets that Medicaid does not count. They're very similar to what the VA looks at. Your residence, your vehicle, your primary, your personal property rather. If you have any term life insurance, that's non-countable. And then one interesting exempt asset in the state of South Carolina is if you have an IRA or a 401k or other qualified retirement account, as long as you are receiving income from that account, the principal is non-countable. It's an exempt asset. And so it doesn't go into the calculation of the $68,000 resource if you're married, or the $2,000 if you are single. One issue to think about that a lot of people get nervous about is because the residence is an excluded asset, you can still qualify for Medicaid and own a home, all right? That home will just continue to be owned by you and in your name if you are receiving Medicaid at a nursing home. However, if you were to pass away and you own a home, the state of South Carolina has a right to put a lien on your house. We call that estate recovery. They have the ability to put a lien on your house based on the value that they paid for your care. And so we have to consider on the backside whether it makes sense to qualify for Medicaid or not, knowing that we could have to deal with estate recovery. A couple of things that people try to do to get under the net worth cap. They try to transfer assets to other people, maybe to their children, to other family members. Medicaid has a 5-year look back. And so what they do is they ask you in your application for Medicaid, have you transferred any assets within the last 5 years? And if you have, they're going to penalize you for those transfers. So transfers for Medicaid and transfers for the VA are a problem, and we have to make sure that we have a good plan to deal with those. A couple of downsides to transferring your assets to other people. You know, of course, you lose control of those assets. Those assets could be exposed to your children or other family members, creditors, divorces, or lawsuits. And in cases where we have real estate, or say we have stock that we're giving away that has a lot of gain that's been accrued during our lifetime, There are some tax disadvantages to giving that to our children during our lifetime because they'll get a carryover basis and they won't have the tax advantage of inheriting property from us. And so there are some difficulties with just transferring assets to children. So now that I've depressed you all about that whole scenario, there is a potential solution that I think works for people that are relatively healthy, that are not looking, at needing nursing home anytime soon. The Irrevocable Trust. This is our fourth estate planning tool. And what we do, the general calculation is we look at somebody's assets. We look at their net worth, whether you have a house, if you own land, if you have a long-term investment account. We look at those as vulnerable assets that we want to try and protect. And so what we do is we take those assets potentially and transfer them to an irrevocable trust. If the irrevocable trust is the owner, those assets are exempt. They do not count for Medicaid or VA purposes. And so we still have to deal, however, with the 5-year look back period and the 3-year look back period. So this is a pre-planning technique. This is something you would do when you are healthy. When you know that you've got 3 years or 5 years where you're not going to need care, this is a very powerful planning tool. A couple of benefits. You can remain trustee of the irrevocable trust. You can control the trust during your lifetime. It avoids probate. So just like the revocable trust we talked about earlier, the primary reason we do a trust plan as opposed to a will plan is to avoid the court system. Well, the irrevocable trust works the same way. So it's like that box. If we put assets inside the box to protect them, they will pass to our beneficiaries without going through the court system. The purpose of that trust, of course, is to shelter the assets that we put inside. Another benefit is that it preserves the tax basis step up. So what that means is if we put our house or our land or our highly appreciated stock into a trust, and then our children or other family members inherit that later, they will get a step up in basis. They get a tax benefit from inheriting property from us. And then ultimately, if we have this trust created and we've put assets inside of it, the trust assets can still be used for our benefit. So how is that even possible? The way that the trust is designed, you would serve as trustee of the trust. You control it yourself. What you can't do is make a direct distribution to yourself, however, from the irrevocable trust. What you can do is make a distribution to a allowed or qualified beneficiary. Typically, this is going to be your children. This might be another descendant. It could be another family member. It could be a friend that you have identified as a trustworthy person that the trust can make a distribution to. Then in turn, that beneficiary can either use trust money to pay an expense for you, or they can give it back to you individually directly. We call that the two-step process. It goes from trust to beneficiary and then to you. So that's the safety valve really with this irrevocable trust plan. If you don't have somebody that can serve as what we call that lifetime beneficiary, that irrevocable trust plan will not make sense. It won't be something that you would want to take advantage of. But if you do have close family, close friends that you can use as a beneficiary, sometimes this type of planning makes a lot of sense, especially with assets that we're not really going to need, like real estate. We're not going to plan on selling our home potentially, or losing or selling our land. Those are static assets that we might want to protect. An irrevocable trust is a good tool to do that. All right. So I know that was a lot of information to throw at you. Kind of going over the summary, we had 4 basic estate planning tools that I wanted to go over. The most traditional is your last will and testament. Everybody over the age of 18 in the state of South Carolina needs a last will and testament. Again, whether you're single, married, young or old. A couple other tools that we use, the revocable trust is an alternative to the will plan. And the primary reason we would do that is to avoid the probate court. The special needs trust is a tool that we use specifically for disabled beneficiaries when we want to make sure that inheritance doesn't impact their eligibility for public benefits like Medicaid and SSI. And then ultimately, the irrevocable trust is a tool that we use for long-term care planning when we have assets that we want to protect from having to be spent down on long-term care in a worst case scenario, we can use a trust potentially to do that. And that irrevocable trust will avoid probate. So these are 4 important tools that I think everybody needs to know about. And so that kind of concludes my presentation.
You are correct in saying that that is a ton of information.
Yes, it is. Yes.
And you know, you try to like, okay, wait a minute, I'm still focusing. And it's what I like most about continuing to offer this type of education is, number one, your different periods at different times. Things matter sometimes and don't, but it's the pre-planning. Nobody wants to talk about it because it's like you said, I'm sorry to depress everybody, but the pre-planning makes such a big difference.
Yes.
Not waiting until, like, I didn't know about the 3-year and the 5-year look backs. You know, even little things, like we just bought a house and I keep money in cash in my house that I can't use because I can't prove where it came from, even though, you know, because you have to have that look back over 3 months of where your income came from. So
Right.
the pre-planning makes such a big difference. I have one question. When you're talking about Medicaid, why is there such a huge discrepancy between married and single? I mean, 68,000 and 2,000?
Right. So the public policy behind that is that the state of South Carolina doesn't want a healthy spouse to be completely destitute, right? So that's why they allow a married couple to have assets or resources up to $68,000. But when you are single, what Medicaid requires, or what the state's going to require, is that you don't have any dependents at that point. And so they're going to require that you spend down all of your assets until you get to that $2,000 level. But you have to remember, that doesn't mean only $2,000. There are some excluded assets like your house, your car, your burial, you know, your term life insurance, personal property. But it is a significant difference. And then I don't know if you picked up, there's a difference between states as well.
Right. I saw that. Georgia allows a lot more.
That's right. In South Carolina, 68,000. In Georgia, it's double that. So, I mean, I've had clients that actually considered moving to Georgia because they were able to double the amount they could keep and still qualify for Medicaid. So it depends on where you live. And I will say the Medicaid rules differ in every state.
That's crazy.
Yeah.
Well, thank you so much for the time. I'd like to, with the, you know, we have a few minutes left, open it up to questions from everybody who's on the call. Did you have questions ahead of time, or did something that Brandon say create a question for you? I know everyone's muted, so you'll have to unmute if you wanted to ask a question. Brandon, can you actually maybe stop sharing and then we can see who's talking? That might be easier for everybody too.
Sure. Is that better?
Hi, everyone. Now I can see all your faces. Does anybody have a question here for Brandon?
Can one person have a will and the other one have a trust?
If you're talking about a married couple?
Mm-hmm.
You can. A lot of times, though, it makes sense to do joint planning. So if you're going to have a trust plan, a lot of times what I'll do for a married couple is have a joint trust where you're both the creators of the trust and you are both trustees. And so you control that trust together during your lifetime. If something happens to one of the spouses, then the surviving spouse is in control and is the sole beneficiary. And then when the surviving spouse passes, that trust will pass on then to the children or other beneficiaries.
Okay, but that's got to be done pre-planning.
That's something, I mean, that's something that you would do together now. Yes.
A question. My wife and I had our wills made up when we lived in Georgia. We now live in South Carolina. Should we have our will in Georgia evaluated by a South Carolina attorney and moved here? So
from a legal perspective, your wills that were made in Georgia are just as effective in South Carolina as they were when you were a resident of Georgia. There's no legal problem. However, I would say that if you're going to live in South Carolina permanently, it probably makes sense for you to have those documents at least updated so that they don't reference Georgia law anymore.
Would your company do that?
Yes. Yeah. I'll be happy to look at your will if you'd like me to.
So it's just a matter of contacting you then.
Yeah. You just reach out to my office and they can schedule a time.
Okay, thank you.
And that's
Appreciate
what I was going to say too. You know, if people just have those questions and want to meet with you, let us know. I'm happy to share your contact information, or if you want to put it in the chat, Brandon, you can do that too. So they know how to reach out just for that consultation.
Yeah, perfect. All right.
How often should you update your will?
So I think that it makes sense to take a look at your estate planning documents, say every 5 to 10 years, or if there's anything that's, you know, substantively different in your family. If, you know, if your spouse passes, if your children have health issues, if you have a grandchild, sometimes you want to review your documents and make sure that they address the needs of your family.
I have a question.
Yes, John.
We took care of my mother. We came from Denver, Colorado to South Carolina. She was in North Carolina at the time. She had been diagnosed with cancer, blood cancer, type of blood cancer, myeloma blood cancer. Anyway, so we had her in palliative care. Eventually, she went to palliative care, decided to stay home totally and not, you know, go back and forth to the hospital so much. And you know, spent down any money that she had from the sale of her home in Colorado at one point, and she lived a little bit in North Carolina. Unfortunately, I had a will made in North Carolina with, you know, with the attorney and with witnesses and all that. However, when she passed in South Carolina after her move from North Carolina, we lost the original will. I couldn't find the original will, but I had a what do you say when it's a notarized copy?
Yeah.
They said no good. Holographic will only. You have to have the original signature on it. Is that basically the case, no matter where it's from?
That's a good point. So in certain states, there is a requirement that you have the original will only. South Carolina is one of those states. We cannot use a copy or a notarized copy. What they essentially do, they still allow you to file the probate application, right, to be appointed as personal representative, but it's as if there was no will.
Oh, okay.
Yeah.
And I think they said, now you can go, they said, you need to go back and look for it again. I said, well, I looked through the whole house. They said, well, you can go back and look again. They said, you have 10 years.
Yeah, that's right. So yeah, exactly. Yeah, they want you to probate the will within 10 years in the state of South Carolina.
All right.
Yeah.
What about the rule of 55? Does that affect most of us in some way?
And remind me of that rule.
Rule of 55 says that I can take money out of my 401k or out of my IRA if I'm 55 or older. Yeah,
and you may want to take a
10% fee, you know, the penalty.
Right. You may want to take a look at the law on this, or talk to your accountant. There were some changes, significant changes in the last year on 401k IRA distributions. For example, if you leave an IRA to your children as beneficiaries, they will only have 10 years from inheriting that IRA to distribute the entire amount. So if you leave them, say, $100,000 in an IRA, they're going to have to take that $100,000 out and pay taxes on it within 10 years of receiving it. That used to not be the case. It used to be that children or other beneficiaries could keep the IRA and keep it over their lifetime and only have to distribute a certain amount based on their age. The laws changed on that. And I believe that the requirement for distributions also changed, where you, instead of 70 and a half, if you turn 72, you have to start taking distributions from your IRAs. I don't recall if the early withdrawal penalty stayed in place at 55. I'm not sure.
Thank you.
Yeah.
Anybody else with a question?
I do. Can y'all hear me?
Yes.
Hey.
Okay, great. So what happens when one of the spouses is struggling with dementia, being moved into memory care, and they do not have these documents in place? I know a lot of our members, may be in this situation. It's currently going on in my extended family right now as well. So what guidance would you give?
Yeah. Yeah. So that's a difficult place to be in because there's a certain time when an individual may not be able to sign any legal documents. What I would say is that what's interesting about estate planning is that the law says that the attorney makes a determination regarding capacity of the signer. We don't have to have a doctor's examination done or a doctor's opinion that an individual has capacity or not. If they've been diagnosed, however, with Alzheimer's, dementia, any other memory loss disease, that is a scenario where attorneys will be very reluctant to prepare estate planning documents. Ultimately, if it gets to the point where it is clear that someone cannot sign estate planning documents, they have no lucid intervals or lucid moments, then the only way to deal with the scenario of managing their health care, managing their financial obligations, is to go through the court system. The court has a system set up where you can apply to be appointed as a conservator or a guardian. The conservator is responsible for the income and assets of an individual, of an incapacitated person. The guardian is responsible for the healthcare and the general well-being of an incapacitated person. The downside is that in South Carolina, it takes us about 4 months to get through that process. And it costs close to $4,000 or $5,000. It is expensive. There are multiple parties involved. We have to get multiple attorneys involved. We have to get multiple medical practitioners involved in the process. So unfortunately, when you don't have a power of attorney, when you don't have a durable power of attorney or healthcare power of attorney, the only alternative is to go to the courts.
If you have the power of attorney.
And so that's one of the reasons that I try to do these community talks, is because the alternative of getting a power of attorney is so much easier and is so much less expensive, that everybody needs to understand what the realities are if they don't have power of attorney.
Now that power of attorney expires with the death or expiration of the person too.
That's right. Yep. The power of attorney. Yep. Power of attorney becomes void upon death.
Quick
And
question.
then it's your beneficiary, it's whoever is listed in your will, right?
Correct. Then your will becomes effective, or say you have a trust plan, your trust will be effective upon death.
Is your house a good place to put money? Like, should you pay off your home?
Oh goodness, I am not a financial advisor. I try not to get into to any of that, but I would say from a legal perspective, even if you pass away and you have a mortgage on your property, it is something that we can deal with, either through a will or the trust. It's not going to be a huge problem for the family.
Is it a good way to keep it from Medicaid or from going towards costs, like you said?
So say you are trying to be strategic, right? And you have assets that are above the Medicaid net worth limit. One of the things you can do is improve your home, make improvements, or you could pay off a mortgage. That would be one way to legitimately reduce your net worth.
Thank you.
Yes.
All right. Well, we are a little after 12 here, so we will let Brandon off the hook. But thank you so much for your time and all your expertise. And again, to everyone on the call, if you want to set up a consultation or you want to have your all your affairs looked at, let us know. I'll get you guys connected, and or you can just reach out. They're Burroughs Elijah, and you can Google them and find them that way as well. But thank you so much, Brandon, for the time.
Thank you, Lauren. Good to see everybody. Y'all have a good weekend.